Picture this. You are up late, typing into ChatGPT, a draft breakup text, a half-baked business idea, maybe a legal letter you are too nervous to send. You hit enter, get your answer, and close the tab, assuming that conversation lives in a private bubble between you and the model. Now imagine that same chat, months later, printed in a courtroom exhibit binder, passed around by lawyers who have never met you. Because that is exactly the door a new court ruling has just opened. And it does not just affect one or two users. It targets roughly 20 million ChatGPT conversations. A magistrate judge in the New York Times versus OpenAI case has ordered OpenAI to surrender around 20 million identified ChatGPT logs from consumer accounts. OpenAI fought hard to stop it, warned about privacy risks, asked the court to roll it back, and lost. Those logs are not test data. They are real prompts and real outputs from people like you, stripped of names but still full of context, timing, and detail. And here is the twist. This is not just about one newspaper and one tech company. It sets a precedent for how courts can reach into AI chat history in almost any big lawsuit. So what exactly is being handed over? Think scale. 20 million conversations means billions of tokens of user text, enough to map behavior patterns, prompt styles, and how ChatGPT actually answered in the wild. Legal experts are already calling this a landmark moment. It shows that United States courts are comfortable compelling bulk AI usage logs when copyright owners say they need them. But here is the pattern break. The law does not care that you thought your chats were private. Under standard discovery rules, once a judge says those logs are relevant and anonymized enough, they become fair game. All of this is happening inside a sprawling multi-district litigation, a kind of mega case that bundles multiple copyright lawsuits against OpenAI and Microsoft into one federal court. The New York Times case sits at the center, but the discovery orders apply across the whole bundle. That means the rules set here will guide how future plaintiffs, from book authors to record labels, demand AI chat logs. In a minute, we will get into what de-identified really means and why it is not as safe as it sounds. But first, you need to understand how hard OpenAI tried to keep your chats out of this fight and why the judge said no. In court, OpenAI argued that even stripped-down ChatGPT logs are too risky to share. They told the judge that users routinely paste in phone numbers health details, employer names, and other clues that survive simple scrubbing. Give lawyers 20 million such chats, they warned, and you create a mosaic where people can be re-identified despite de-identification. They also argued necessity. The New York Times, they said, did not need raw consumer chats to prove its case. Targeted examples or synthetic tests should be enough. Anything more would be a fishing expedition through private behavior. Magistrate Judge Barbara Moses was not convinced. She pointed to an existing protective order that limits who can see the logs, mainly lawyers, experts, and the court, and that explicitly bans attempts to re-identify users. Combine that with OpenAI's duty to strip names, emails, and direct identifiers, and she called the risk mitigated, not eliminated, but acceptable. Here is the part nobody expected. By arguing in court that its own de-identified logs are still dangerously revealing, OpenAI exposed a gap between its public privacy promises and what its systems actually retain about your chats. For the judge, relevance beat discomfort. To test whether ChatGPT regurgitates New York Times articles, experts need a statistically meaningful slice of real-world use, not a handful of cherry-picked demos. A 20 million log corpus lets them measure how often the model spits out near verbatim news content, under which prompts, and over what time periods. This is modern e-discovery. Big anonymized datasets are fair game when they go to the heart of a claim, and that should make you ask a blunt question. If relevance can outweigh your expectation of secrecy here, where else could your AI chats be pulled in next time? Now, about that comforting word, de-identified. In the AI world, it mostly means the obvious stuff is removed. Names, email addresses, account identifiers, phone numbers, IP addresses, device identifiers. What stays? The full prompts and the full responses. Privacy researchers call this a weak form of anonymity because real life does not fit neatly into a redaction script. Your conversations often mix workplace details, relationship drama, financial specifics, and health information in the same thread. That rich narrative context becomes a fingerprint. Re-identification risk kicks in when those details intersect. Imagine a user typing, "the only pediatric cardiologist in Anchorage who treats my kid's rare condition," or "my role as the sole machine learning engineer at a 12-person fintech in Boise." Strip the name and email, and you still have a profile that can narrow to one person with a few outside data points. Some prompts basically dox the user without ever naming them. A press release draft for an unreleased product at a very specific startup. An internal memo about a confidential acquisition. A student describing a disciplinary case at a named university. Privacy experts have warned for years that large text corpora are hostile terrain for anonymity. Research by LaTanya Sweeney famously showed that most Americans could be uniquely identified with just zip code, birth date, and sex. A chat log usually carries far richer combinations of traits. Legal scholars now argue that de-identified often really means temporarily inconvenient to identify, not truly anonymous. Yet courts increasingly accept de-identification plus a protective order as good enough. That is exactly the logic the magistrate judge leaned on in forcing OpenAI to produce these logs. Remember, copyright, not privacy, is the official center of this case. The New York Times accuses OpenAI and Microsoft of mass copyright infringement, claiming GPT models ingested millions of times articles, then learned to spit them back nearly verbatim. Their complaint shows side-by-side comparisons where ChatGPT allegedly outputs long, paywalled passages from deep investigations. For the Times, those 20 million logs are a discovery goldmine. They want to hunt for real-world prompts where ChatGPT recites Times stories, summarizes paywalled reporting in suspicious detail, or cites Times work without permission or payment. OpenAI counters that training on publicly accessible text is fair use. They argue that large language models transform raw text into statistical weights, not a replacement archive, and that the new purpose is a general conversational assistant. Big tech players like Google and Meta back this logic. They warn that if training on public web data is infringement, modern AI collapses under its own legal weight. Here is the strategic twist. On one side, you have creators saying, "You built a competing product on our work." On the other, AI labs saying, "If we cannot learn from the web, only the richest companies with paid data deals will survive." Ethically, every smooth ChatGPT reply now looks different. High-performing models demand vast, messy datasets. Newsrooms, blogs, forums, code repositories, social feeds, and yes, your private-feeling prompts. The more courts force companies to surface logs to prove or disprove infringement, the more you discover that your so-called private chats are on the front line of a billion-dollar copyright war. This is not just theory. It shapes how safe you should feel pasting anything sensitive into a consumer AI tool. In a moment, we will talk about why business users get a very different deal, and why that matters if you ever type work secrets into ChatGPT. Here is the tale of two privacy policies. Consumer ChatGPT and enterprise ChatGPT live under totally different rules. When OpenAI talks about handing over consumer logs, it means the free tier, the plus tier, and most casual API traffic. That is the side of the business that runs on scale, not on bespoke contracts. Enterprise customers, by contrast, buy something very different. Products like ChatGPT Enterprise, ChatGPT Team, and Microsoft's commercial data protection flavor of Copilot come with explicit promises. Your prompts and outputs do not train the models by default, and logs stay fenced inside your tenant. Those enterprise guarantees live in contracts, not in marketing blurbs. Agreements spell out data processing, retention, and audit rights in pages of legal language. Who can access logs, under what conditions, and for how long? If a Fortune 500 company signs a deal saying no training on our data, violating that is a breach of contract with real liability. The New York Times discovery order zeroes in on the other side of the house. Retained consumer logs. The chats from millions of people using a shared multi-tenant service that OpenAI runs and logs centrally. And that drives home an old truth. If the product is free, you are the product. For businesses, professionals, and even solo practitioners, the message is blunt. If you feed confidential work into consumer-grade ChatGPT or Copilot, you now have a court order proving those chats can end up in someone else's hands. De-identified, yes, but still discoverable. Court-ordered access to 20 million logs does not create a brand new power. It plugs AI chats into a system that already hoovers up digital life. Under e-discovery, lawyers routinely subpoena email, Slack, iMessage, Google Docs, and server logs. Now, your AI conversations sit in the same evidentiary bucket. Judges in complex cases expect comprehensive electronic evidence, timestamps, IP ranges, device identifiers, and message content. By ordering OpenAI to produce a massive sample of day-identified logs, the court effectively blessed AI chat histories as fair game, as long as they pass the usual tests of relevance and proportionality. That precedent will not stay confined to one copyright fight. Employees already get burned when work email or Slack messages show up in lawsuits over harassment, trade secrets, or fraud. Swap in ChatGPT. A product manager pasting unreleased roadmap details. A lawyer drafting arguments with client facts. A doctor experimenting with diagnoses. Those prompts now look a lot like discoverable business records. And it is not just work. People routinely feed ChatGPT details about divorces, immigration issues, tax problems, or mental health struggles to get what feels like private advice. If any of that overlaps with a later dispute, family court, employment litigation, even a criminal investigation, lawyers will ask whether AI chats exist and which company logs them. You should treat every prompt to consumer ChatGPT, Claude, Gemini, or Copilot as if it might someday appear on a PDF labeled Plaintiff's Exhibit 47. Day identification strips obvious labels, but rich narrative detail can still point straight at you. So what can you actually do to protect yourself? Start with a simple rule. Do not put anything into a consumer AI chat that you would be uncomfortable seeing in a courtroom or in the hands of an opposing lawyer. If you genuinely need confidentiality, use tools covered by an enterprise or business contract, or keep sensitive drafting offline. Assume that consumer AI chats are logged, that logs can be preserved for years if litigation appears, and that courts can compel production under protective orders. In a moment, I will recap the key takeaways so you can adjust how you use these tools starting today. Here is the new reality in one line. The future of AI is less private than you think. A federal court has just shown that when copyright plaintiffs want to probe how a flagship model behaves, your chats can become their evidence, even with names removed. OpenAI tried to argue that the logs were too revealing to share and lost. Day identification turned out to be a legal comfort blanket, not a real privacy shield. Consumer and enterprise users live in different universes, and only one of them has contract-level protection. So as you keep using tools like ChatGPT, Claude, Gemini, and Copilot, remember the stakes. Your late-night brainstorms, your rough drafts, your personal worries, once they hit those servers, they are not just conversations. They are potential evidence, potential training data, and now potential ammunition in someone else's lawsuit. If you want more deep dives on how